And he also testified that at times his speech was mumbling. Do you remember that?
I did say that, sir, yes.
Okay. And did you ever put it together that maybe the injuries he had sustained would have any effect on his ability to speak? Did you put that together at all? Now, after you get him out of the car, you've made some observations of him prior to deciding to get him out of the car, right?
Yes, the observations were made.
Okay. And the observations were of his driving, correct? That was one of the observations.
That is correct.
And you testified to some, whatever day's testimony you'd like to use, but him not maintaining the exact center of his lane, correct?
That is correct.
Okay, now a person's allowed to use their whole lane. There's nothing, even a civil infraction about that, is there?
I don't see why exactly.
Okay. And you know that speeding, I mean, you're trained about looking for signs of intoxication, right? As far as driving go, like weaving, ignoring red lights, that kind of stuff, right?
Yes, sir.
You know that speeding, there's no correlation between speeding and intoxication, correct?
People that speed have also been known. Well, I should rephrase that. Intoxicated drivers have also been known to drive at high rates of speed.
Did you in fact ask him why he was speeding?
I don't recall.
Did you recall him answering you that question and saying he was in a hurry to get home to make a report?
Objection, Your Honor. Once again, same objection. Calls for hearsay.
All right. What's your response, Mr. Ambrose? Why is this not hearsay?
I can always recall the officer again.
All right, then. Objection to sustain.
So you observed the driving, and then you made some other observations of Ken Edwards when you had him on the side of the road, correct?
Yes.
And one of those observations was an odor of intoxicants.
Yes, emitted from the vehicle on himself.
And you know that based upon the odor of intoxicants, you can't tell how much a person's drank, correct?
That is correct.
Just that they've drank something.
That's it, right.
And he admitted to you that he had drank something, correct?
Yes, sir.
And his speech wasn't slurred, was it?
Not that I can recall.
Okay, if you observe slurred speech, that would be in your report.
Yes, sir.
Because that, you're trained as a sign of intoxication.
Yes, sir.
And so based upon his driving and this odor of intoxicants, and he also said he had glassy eyes, is that right?
I put that in my report, sir.
Now, as far as glassy eyes goes, you know there's a lot of reasons why a person has glassy eyes, correct?
There could be many reasons.
Okay, I mean, it could be just because they're tired?
An expert, correct.
They're wearing contacts?
It could be a number of reasons.
Okay. It could be because they're tired.
It very well could be.
Could be because they're wearing contacts.
Very well could be, sir.
It could be that they were just in a smoky environment and their eyes are irritated.
Those are, once again, many reasons, correct.
Okay. Did you ask Mr. Edwards if the reasons why his eyes were glassy were for any of those reasons?
No, I don't recall.
You saying you may have asked him, but you just have no memory?
I don't remember asking him that question, sir.
Is that because you didn't ask him those questions?
I did not ask those questions, sir.
Thank you. And you just assumed that it had to do with intoxication, correct?
Led me to believe. Yes.
And so at this point, you asked him to step from his car to perform your test.
Yes, sir.
And we talked about physical things that could affect a person's ability to do your test, right?
Yes, sir.
Now, if a person had just been beat up, could that affect their ability to perform your test?
It could be a one factor.
In the first test, you have them, and you're trying to establish your probable cause, right?
That's correct.
And so that's why you have him do these tests.
Yes, sir.
And so the first one is the alphabet, and after that one, you still have an open mind.
Yes, sir.
You haven't made a decision to arrest him or not.
In my mind, I mean, my decision was made, but I wanted more information. I wanted to see more tests and go from there.
Okay, so prior to even having him do the alphabet, you had already made up your mind that you were arresting him, correct?
No, but it was leading in that direction, sir.
So after the alphabet, you still haven't arrested him, correct?
That is correct. I did not.
And after he has the finger the nose test, right?
That is correct.
And you told us he failed to follow your directions on that one.
Yes.
Okay, after he does the finger the nose test, do you still have an open mind, or have you decided to arrest him?
I still have an open mind because I had not yet arrested him.
Okay, it was only after the walk and turn test that you decided to arrest him, correct?
I felt that there was, after the walk and turn, that there was enough probable cause to make an arrest and take him in for a breath test at the station.
And you testified that he told you that he had a couple of beers, right?
Yes, sir.
And had he told you he had nothing to drink, that wouldn't have been the end of your investigation, would it? I mean, he said, I had nothing to drink. Would you just said, oh, here's your speeding ticket. Have a good day?
No.
Had he told you he had 6 beers throughout the course of the evening, you would have still continued the investigation, right? You wouldn't have said, oh, well, 6 beers, that doesn't seem like a lot. You can go on your way?
Yes, sir. Still continue on with the investigation.
Okay. In fact, did you ask him what time he had started drinking that evening?
Yes, I did, sir.
Okay. And he told you around, what, 8:30?
May I review my report, sir?
Sure.
On the, once again, Southfield Psycho narrative, I put that 8 o'clock was the start time that he had started drinking that night.
So you, no matter what he told you had to drink or didn't have to drink, you were going to continue with your investigation. Is that correct?
Yes, sir.
He was cooperative throughout this investigation with you?
Yes, sir.
Now, you perform these tests on the side of the road, correct?
Yes, sir.
And there's other, you got your overhead lights on?
Yes, sir. The overheads are on.
There's other cars driving by?
Yes.
You've been an officer for how many years?
4 years, 4.5.
Okay, and I assume it takes a little bit of getting used to standing on the side of the road with cars going by. Is that correct?
I didn't find a... I mean, yeah, you could have to get used to standing on the side of the road with cars going by. But when there's areas blocked off for you, I wouldn't see a problem.
The question was, it takes some getting used to, right?
It could.
And as far as, did you give Ken Edwards any time to get used to the surroundings before you started giving him these tests?
There was about 9 minutes between him getting out of the car and before I administered the test.
Okay.
So that could have been enough time.
Now, when you do these tests with him, especially the walking test, walking turn, you have military-style boots on like you're wearing today. Is that correct?
That is correct, sir.
And those have good supports, good treads on them?
I don't want to say about treads, but yeah.
And as far as, and those are different than like dress shoes, correct?
Yes, they are different than dress shoes.
Before you start giving him these tests, because you are grading these tests, right?
I'm making observations of the test, correct, sir.
Okay, and I assume if he passes them, then you're going to let him go, and if he fails them, you're going to arrest him. Is that true?
I'd have to go on further with my investigation.
All right. Well, did you tell him what he'd be graded on? As far as these tests go?
I don't recall.
So you may have told him what he was graded on, but you just have no memory of it.
I don't recall.
Now, these field tests that you gave him, these are really just observations, correct? Sort of like speech or his eyes or an odor. They're just observations of yours.
Observations, sir.
Okay, there's no scientific relationship between a person's ability to say the alphabet and having a .08 or higher, is there?
Objection, Your Honor. This question's been asked and answered. It also asks for a scientific conclusion, Your Honor. This is a lay witness, not
Yeah,
an
it's
expert
no
witness.
foundation whatsoever here, Ms. Ambrose. He's qualified to answer the scientific conclusion here, being a lay witness.
Well, officer, as far as... Well, you're not an expert in field sobriety tests, are you?
Not an expert, no.
Okay. Officer, before testifying today, you reviewed your police report that you generated for this incident,
Yes.
and you discussed the case with Officer Wysocki,
Yes.
and you reviewed your testimony that you gave on October 3rd, 2006,
Yes.
and you further reviewed your testimony that you gave on November 15th, 2006.
Yes.
And you also discussed the case with this prosecutor.
Correct.
And you know that an issue in this case is whether Ken had blood in his mouth when he took the data master, correct?
Yes.
And you know that if you were to testify that, in fact, Ken did have blood in his mouth, that would invalidate the breath test results.
Correct.
And you know that if you testify that there's cuts or abrasions in the mouth, that would make the test inadmissible.
Correct.
And so your job here today is to validate the results of the breath test, correct?
Yes.
Now, this is the first breath test you've ever given to an actual subject in your career, correct?
Yes, it was.
As far as it getting an accurate reading, you said it gave an accurate reading. True? I mean, it gave a reading. The instrument gave a reading.
Yes, the instrument gave a reading.
And that was after you observed him for 15 minutes.
Correct.
Did you also testify that, because I can't remember if you testified this time or it was last time, that if there was any residual alcohol in his mouth, that it would read an invalid sample?
Yes.
Okay. Well, if that's the case, then you wouldn't really need to do a 15-minute observation period, would you?
Well, I wouldn't be able to tell if there was or not.
Now, as far as his chemical test rights, you told him that he has a right to an independent test.
He read along as I read to him.
Okay. Did you ever suggest to him at any time that if he disagreed with the results, that he should go and get and ask you to get a blood test right then and there?
No.
Did you ever say to him, you know, if you disagree, now is the only time to get a blood test?
No.
As far as him asking you to use the sink to wash his hands, you testified just now that that happened after you began your 15-minute observation period. Is that correct?
Yes.
And do you remember previously testifying on, October 10th, 2006, that he actually used the sink before you started your 15-minute observation period?
No, I don't.
The question's on page 17 at line 14. If I approached you and showed you your testimony, would that refresh your memory?
Sure.
And you just read this transcript today before you came to court, right?
I read a transcript, yeah.
On line 14, I asked you the question. Do you remember Ken using the sink prior to the observation period beginning?
Yes.
And what did you say?
That he did use to wash hands before the observation period.
But you further testified today that he did not rinse his mouth out, correct?
That's correct.
Now, in the police report that you wrote, do you have a copy of your police report there that you wrote in this case?
I do not have it right now, no.
Do you have it? Why don't you look at it? My first witness, Sharon.
Yes.
So, do you remember writing in this police report that you checked the inside of the suspect's mouth for any objects and advised him on burping?
Yes.
Nowhere in the police report do you write anything about looking for blood in his mouth. Is that correct?
No.
What I'm saying is a correct statement, right?
Yes.
And you don't advise, you never ask him if he has any cuts or blood in his mouth, correct?
No, I did not.
Even though you can see abrasions on his face and you know that he claims, he told Wysocki that he'd been assaulted in
Objection
Detroit.
calls for hearsay, and it's also lack of personal knowledge.
Stay.
Thank you.
Did you write in your police report that he had visible scratches and injuries from an assault in Detroit?
No. I believe so.
I approach a witness again, Your Honor.
Yes. Okay, so you in fact did write that, correct?
Yes. It's been a while.
But you reviewed this before coming to testify today, didn't you?
No, I reviewed the transcripts from earlier.
Okay, knowing that he'd been assaulted, do you ask him to look, knowing that he's been assaulted, you know that he may have sustained other injuries, correct?
Objection calls for speculation.
Sustained.
On October 10th, 2006, do you remember the prosecutor asking you if in fact...
Your Honor, I'm going to object to the phrasing of the question. He's asking if he remembers something about prior testimony. If he has a question as it relates to this case, he can ask the question as it relates to this case. It isn't a memory test. It's a question of, does he know this stuff? If he says something inconsistent with whatever it is he wants to get at, he's free to try to attempt to impeach him or refresh his memory with the transcript.
I'll rephrase the question, Your Honor.
Well, thank you. That's sustained.
Thank you.
Do you remember the prior hearing being asked a question? What's the purpose of inspecting the defendant's mouth?
Your Honor, I'm gonna renew my
It's the
objection.
same objection. It's the same question.
Thank you, Your Honor.
Do you remember testifying at a prior hearing?
Your Honor,
I haven't asked the question yet, Your Honor.
do you remember testifying at the prior hearing?
What you need to do first, I guess, Mr. Ambrose, is you need to ask a question that somehow establishes that he doesn't recall it or says something different. Then you can refer back to the prior hearing to impeach him or refresh his memory, whichever way you want to do it.
Okay, thank you, Your Honor. Have you testified?
Your Honor,
Don't refer back to what he said before. Just ask him a straight question right now about whatever the factual information is that you want to establish. He may very well say, yes, I said that. Then you don't need to refer to the prior transcript. If he says, no, I didn't say that, or if he says, I don't remember that, then you can say, looking at the prior testimony that you gave, X, Y, Z. So just ask him a straight question first and see what the response will be before you attempt to use the prior transcript. Let me see.
The purpose of inspecting the defendant's mouth is to check it for vomit or any alcohol in the saliva. Is that correct?
Yes.
Or anything that could pretty much block the testing tube?
Correct.
And that's the answer you give when the prosecutor first asks you about it,
Your Honor,
correct?
I'm going to renew my objection to this question. he's asking what his answer was now at a previous testing. The first two questions he just asked after this were acceptable, but this one isn't. He's now trying to...
I'm trying to establish the evolution of his testimony, Your Honor. The fact that initially in his report, he doesn't put anything about looking for blood in his mouth. And then the first time he's asked about it by the prosecutor, he doesn't mention anything about looking for blood, and he only mentions looking for blood in his mouth after the prosecutor suggests it to him. That's what I'm establishing, Your Honor.
And I don't see how the evolution, as he wants to call it, of his testimony is particularly relevant. The question is whether or not he's ever said anything inconsistent. And if he wants to attempt to impeach him with an inconsistency, he's free to do that. But to ask him if he ever remembers being asked a certain question and at what time he remembers being asked it is an improper form of impeachment or cross-examination.
I would agree, Mr. Ambrose, but I do think that if you have an inconsistent statement that he made previously, that you can ask him about that.
When the prosecutor first asks you about why you check his mouth, let me just ask a
All right,
question.
let him ask a question. Let's see where he's going.
You don't mention looking for blood in his mouth or cuts in his mouth, correct?
Your Honor, it's the same objection. He hasn't done anything. He has not established whether or not there's anything to impeach him with. He's simply asking him to remember what his prior testimony was without seeing if there's anything inconsistent prior.
What?
We've been through this 5
Establish
times.
the fact that there's an inconsistency first. Then refer back to where it is in the transcript that it's inconsistent. We don't know if there's an inconsistency yet.
When you were looking in his mouth on the night that you give him this test, are you specifically looking for blood?
No, I'm looking for multiple things.
Okay. And some of these things that you state that you're looking for are vomit or alcohol in the saliva or anything that block the testing tube, correct?
Yes.
And what does alcohol in saliva look like?
I might have misspoken. You cannot see alcohol in the saliva.
And as far as seeing cuts or abrasions in his mouth, you don't testify to that until the prosecutor asks you if you see any cuts or
Objection, Your
abrasions.
Honor. This is the same thing that we've been through. He's not impeaching him on this. He's simply...
Press the bench, please. And bring your transcript, please. Let me see your transcript.
We asked him why he checks inside his mouth. Specifically states for that. It's not until the prosecutor asks him specifically.
And that's not evidence. The sequence of questioning is not evidence.
It is if the question suggests the answer.
It doesn't. And first of all, you never objected to a leading question. It's a specific question to ask if he saw a specific thing. It's not. That's not how you get to do this.
That's the point. Did you see anything different? Stop. No. Did you see any customer abrasions inside your mouth? Inside? No. What's your point?
Points. He doesn't reference anything about customer abrasions in his mouth. He just reference about the customer abrasions in his mouth until the prosecutor asks him.
Why is that relevant? If he says that he didn't look for it, which is what he's saying today, it's not inconsistent with what he said here. And he did ask the question, did you see anything in his mouth? No. Did you see any cuts and abrasions? No. It's all consistent with what has been established today. So I don't see what you'd be trying to impeach him on. Although I do see what you're saying is that the prosecutor asked the question, but it doesn't matter who asked the question. The answer was consistent and it wasn't leading.
Thank you, Your Honor.
Oh, wait a minute.
Thank you, and I'll admit this on my redirect.
All right, go ahead, Mr. Ambrose.
Thank you, Your Honor. Now, when you do inspect the inside of his mouth, you're just using a regular flashlight, correct?
My issued flashlight.
That's a regular flashlight.
It has a higher illuminating power than most flashlights do.
But there's nothing specific about it to detect. It's not like an infrared or anything like that
No.
that would detect blood or anything like that, correct? And when you inspect the inside of his mouth, you have him open up his mouth like this. Like he's at the dentist.
Correct.
Correct? you don't have him show you the inside of his lips at all, correct?
Correct.
And you never ask him if he's bleeding inside of his mouth?
No.
And you never ask him to spit into a cup or anything like that to see if he's bleeding inside of his mouth?
No.
Or use a cotton swab to see if he's bleeding inside of his mouth?
No.
And you warn him about burping because you know that will invalidate a test.
Correct.
But you choose not to advise him about whether he has blood in his mouth. Because you, correct?
Correct.
But you know that will invalidate a test, correct?
Correct.
And when you testify in the same case on November 15th,
Your Honor, I'm going to renew my objection at this point. I don't see how he needs to phrase his question to get an answer first before he attempts to go to the prior testimony.
okay. Well, when you on November 15th, you give a different answer to the same question the prosecutor asked you about why you look in Ken Edwards' mouth. Is that correct?
I don't recall.
If I showed you your testimony, would that refresh your memory?
Yeah.
That's volume 2, right? Yeah. Mr. Ambrose, that was page 9,
Page 11.
page 11, line 9.
And what's the reason you give for looking in his mouth on that day?
See if there's any cuts or
Your Honor,
abrasions.
for the rule of completeness, I'd request that counsel read the full question from the transcript into the record as well as the full response.
Okay, the full question was, as part of your testing procedure, are you required to look in the suspect's mouth? Answer, yes. Did you do that in this case? Answer, yes, I did. Question, okay. Can you walk me through how you went about doing this? Answer, in the 15-minute observation period, I read Mr. Edwards' chemical test rates, looked inside of his mouth with my flashlight to make sure there wasn't any cuts or abrasions inside there.
Thank you.
Correct, officer?
Yes.
On that day, you don't mention anything about looking for alcohol in the saliva or anything about vomit or anything that'll block the tube, right?
Correct.
And you know on that day how important it is that there's no blood or cuts in his mouth, correct?
Yes.
Just like today.
Yes.
And on that day, you meet with the prosecutor to discuss your testimony,
Yes.
just like you did prior to today's trial.
Yes.
I don't have any further questions, Your Honor.
Any redirect?
Yes, Your Honor. Officer Freeman, counsel indicated that you talked to me about your testimony today. Is that correct? How many minutes do you think we spent talking about your testimony?
Probably less than 5.
And I talked to you a couple of times over the last 2 days. Is that correct?
Correct, on the phone.
Did we talk about how you're going to arrange child care more than we talked about your testimony? So you could be here, or about your testimony more?
Child care was more of an issue.
Okay. Now, counsel indicated something to you about an invalid sample. Would you please explain what an invalid sample reading is on the instrument to the jury?
On your data master evidence read ticket, where there would be numbers that would read out an invalid sample or interference detected instead of numbers, which would make an invalid sample.
And this readout would be printed out if the instrument detected that there was mouth alcohol in the sample.
I object to the leading nature of the question.
I'll
Sister.
rephrase the question. When would this invalid sample read out?
It could be multiple times, whether there would be blood inside the tube, blacking it, or if there was vomit or any type of foreign object.
Now, counsel also asked you about the chemical test rights that you went through with the defendant, and I asked you about it on direct. And may I approach your court reporter, Your Honor?
Yes.
And have this marked?
Yes.
The record should reflect that I provided counsel a copy of proposed exhibit number 4. I'm also handing proposed exhibit 4 to the witness. Do you recognize what I've handed you, sir?
Yes, I do.
What is it that I've handed you?
The chemical test rights that I read to Mr. Edwards.
Okay, and now that you have the document in front of you, would you please read the document, or excuse me, at this time I'm going to move to admit People's Proposed Exhibit 4 as Exhibit 4.
Any objection?
No, Your Honor.
All right, 4 is admitted.
And just for the purposes of the record, would you please read what those chemical test rights detail?
This was the copy that I actually issued to Mr. Edwards, because there was some ones that were not need to be read to him, given the fact that it was the first line was the arresting charge.
Actually, Your Honor, may I approach the witness before he reads it? I
Yes.
want to make sure I'm one thing. All right. I want to make sure that it was appropriately marked. Thank you.
Now, a peace officer, you're going to be arrested for the offense of, and that was the first asterisk that Mr. Edwards followed along with. It was operating a vehicle while under the influence of an alcoholic liquor or a controlled substance or a combination of both with a blood alcohol content of 0.08 grams or more per 100 milliliters of blood per 210 liters of breath per 67 milliliters of urine. Then I had Mr. Edwards skip down to the highlighted area as far as his chemical test rights. That I'm requesting that you take a test to check for the alcohol and or controlled substance in your body. The next paragraph was, if you refuse to take this test, it will not be given out with a court order. If I seek to obtain such a court order, your refusal to take this test shall result in suspension of your operators and or chauffeurs and vehicle designation group or operating privilege, in addition to 6 points on your driving record. After taking my chemical test, you have the right to demand that a person of your own choosing administer a breath, blood, or urine test. You'll give a reasonable opportunity for such test and the obtaining of a chemical analysis of a test sample taken by a person of your own choosing. The results of both tests shall be admissible in a judicial proceeding, will be considered with other admissible evidence and determine your innocence or guilt. And then, will you take this test was the question that I asked him, and he said yes. And he agreed to it.
Thank you. May I retrieve the exhibit?
Yes.
So, after you advised the defendant of these rights, he was informed that he had the ability to obtain an independent test if he disputed the accuracy of these results.
Yeah, I object. It's leading. It has nothing about disputing the accuracy of the results. It just says you have a right to an independent chemical test.
All right.
I'll
Just
rephrase my
rephrase it.
question. The defendant was advised that he had the right to have an independent test. Is that correct?
Yes.
Okay. Now, at some point during your contact with Mr. Mr. Edwards, Mr. Edwards learned, or he was advised that he had a breath test sample of 0.15. Is that correct?
Yes, once the instrument registered the results, I told him what the results were.
Okay. After you told the defendant what the results were, did he make any requests of you to obtain an independent test?
No, we did not.
Thank you. I have nothing further.
Any other cross-examination?
A couple questions, Your Honor. You're not an expert in how in the data master, are you?
No, I'm not.
You don't know how it works?
No.
You simply know how to run a test, correct?
Your Honor, I believe this is beyond the scope of my redirect.
It's not, Your Honor, because I just want to ask him about an invalid sample.
All right, we'll get to the invalid
Okay.
sample. Go ahead.
Have you ever run any experiments on it to determine what percentage of the time an invalid sample will display itself when the instrument detects mouth alcohol?
No.
So you don't know if it works half the time or works all the time,
Your Honor,
correct?
I'm going to object. The witness has already indicated he's never run any tests on it to determine whether or not.
All right, it's just
Thank you.
Yeah, he's answered it.
And just as far you read to him, he had a right to an independent test, correct?
Correct.
That you never suggest to him that if he disputes the results, that now is the time to ask for the blood test, correct?